Probate documents are one of the best primary source documents out there, but they're also one of the most complicated, partly because of the dizzying array of different document types, such as probate proceedings, bonds, letters of administration and other administrativa, inventories and bills of sale, and of course guardianship. I'm Mike O'Neill, and I'm going to give you an overview of different probate documents in 5 minutes, though I'm not sure I'll pull it off on this one. If you want to dig deeper, I recommend spending some time at Bob's Genealogy filing cabinet at genfiles.com. In this video, I'm going to focus on intestate proceedings, where there's no valid will. I'll cover wills and guardianship separately. Now, if you're lucky, these proceedings will be handled by a special purpose court, which can make finding the records a lot easier. For example, in Pennsylvania, the orphans courts handled such proceedings. Intestate proceedings are both complicated and extremely valuable genealogically. The reason the intestate is complicated is that the proceedings are governed by local laws, which reflected cultural mores of the time. But you won't find explicit references to those laws in the proceedings. You'll just see decisions that seem strange today, but were really just run-of-the-mill for the time. Let me give you an example. Colonial Pennsylvania law gave the eldest son the option to buy out his sibling's share of his father's real property, provided he could come up with the funds within 1 year. If you didn't know this, however, you might come to the wrong conclusion. Consider this family genealogy, which states that a Jacob Slow petitioned the court to have his father's estate divided up. The genealogy considers this to be a significant event, and it's all related to a wicked stepfather taking control of the farm and Jacob trying to just seize it back. But it wasn't even worth mentioning, and he wasn't asking for the property to be divided up. Jacob's motion was just a routine procedure in intestate proceedings. Before Jacob could buy out his siblings' share of their father's estate, the law required proof by the testimony of 12, and I quote, disinterested men, that the farm could not be divided into equal shares without diminishing the value of the property. Perhaps it couldn't be partitioned because only one share had access to water. Or perhaps it was because most of the acreage was uncleared, leaving each farmable parcel just too small to support a family. Anyway, in this case, that's all that Jacob was asking, that the court follow a standard procedure outlined in Pennsylvania law to send 12 men to check out the farm and decide whether or not it could be split up. If it couldn't be partitioned, Jacob could buy out his siblings' share of their father's real estate. It's hard to provide specific advice here, since every state will have different laws, but here's the best rule of thumb. If something seems strange in an intestate proceeding, assume that you are the problem, and that what you're seeing is just usual stuff. Then, go look for guidance about the laws of that state to see if you can learn more and make sense of that odd scenario. If you're lucky, you'll find pre-built explanations. Now, Bob's Genealogy filing cabinet, which I mentioned at the beginning of the video, is a pretty good one, but it may come down to finding an old book on WorldCat and requesting it via interlibrary loan. I've actually got a case study video that hinged on how Virginia's intestate laws treated children born out of wedlock. Without obtaining a guidebook for administrators and executors, I can only speculate on what was happening. Intestate probate proceedings are going to follow some boilerplate conventions, the most important of which is that children will almost always be listed in birth order. One common exception is if the firstborn son has special legal rights. In this case, he may be listed ahead of any older sisters. Intestate proceedings may also include assignment of guardians for minor children. Now, pay close attention to this. Many courts will note that a child was below or above a certain age. For probate proceedings taking place over many years, you can get very accurate estimates of when some of the children were born. If you want to learn more about guardianship, I've got a separate video on that topic. Now, intestate proceedings may also include letters of administration, bonds, and an inventory. These are really just administrativa. The only genealogical value is that the people named tend to be family, friends, and even neighbors of the deceased. Sometimes you'll get a relationship for a single person, maybe you'll get an exact date of death, but that's going to be about it. Letters of administration state that a given individual can transact on behalf of the estate until it is settled. Now, if there are minor children, the administrator may keep showing up in court until the youngest child reaches the age of majority. That could be 2 decades. Bonds are a financial guarantee that the administrator and/or guardian won't embezzle from the estate. If a court later found the administrator guilty of financial malfeasance, the administrator would be financially liable for an amount that could be higher than the estimated value of the estate, and that depends on the extent of the malfeasance. The other thing that you may find in an intestate probate proceeding are inventories. Now, this could just be the output of an estate sale, but it could also come in two parts. The first being an estimate of the value of the decedent's personal items, and the actual bill of sale. Now, these can be interesting in learning about the decedent's possessions, but they're generally not going to help you when it comes to genealogy. The bill of sale may include family members buying things owned by their parents, but they won't be identified as such. Anyway, that can be a lead for figuring out who a decedent's daughter's married, but generally speaking, you're not going to get a lot of value from it.